beneath the objective evidence that goes too far.
Counsel, Himelfarb was a civil case, of course, as Justice Campbell said. It was also determined on summary judgment. Here we're on a 12.026 motion. It's a much more lenient toward the plaintiff, of course, puts us in a different posture. How do you respond to that difference?
Himelfarb was a summary judgment case, but the rule that it announced was a rule as a matter of law, and courts that have followed Himelfarb and have encountered a situation where a plaintiff pleads a voluntary non-suit have resolved those cases on 12b6 motions, because what Himelfarb says is that a voluntary dismissal doesn't support a subsequent malicious prosecution suit unless there's something, and of course the plaintiff could plead this, indicating that it is a merits disposition.
Well, the case we're concerned with today, of course, was a retirement. And, of course, I noticed the Court of Appeals put that word in parentheses because you can go around to the state of Tennessee and find 95 different definitions of what retirement of a criminal case or civil case either means. And then it was dismissed, correct?
That's correct, Your Honor.
And you're saying that's not a favorable termination to the plaintiff?
That's correct, and that's for a couple of reasons. So what Mr. Mynatt pled in his complaint when he was describing the way in which his case wrapped up is that what happened at the end of the case is that the prosecutor filed a motion to retire the case for a year, and then on the next court day, the case was dismissed. That's the end of the case. It's retired and dismissed. And inherently, that is not a favorable termination. Generically, that's not a favorable termination for a couple of reasons. One is just as a matter of common sense. If a prosecutor subjectively determines Kenneth Mynatt is innocent, this case has no merit, the prosecutor ethically can't just leave the case hanging over his head for a year as a sword of Damocles. So that suggests that the prosecutor subjectively was not thinking that this was an innocence case at all. The second thing is that, as Tactile said, a defendant has the opportunity to object to a retirement. The defendant could assert their speedy trial rights and say, I'm not waiving those. And the prosecutor then has a serious problem with trying to retire the case.
But counsel, let's step back for a second. Your first point saying that there wouldn't be retirements out there if the prosecutor finds evidence. As a practical matter, I think we all know that doesn't happen. As a practical matter, there are cases retired all the time that sit there for a long period of time, even though the state ends up not prosecuting or may not have any intention of prosecuting anyway. So, I mean, that makes this more complicated, doesn't it? It's not simply that, as soon as the state finds out that they don't think there's enough evidence to prosecute, they're going to run in and dismiss the case. So a retirement could sit out there. All the while, the individual that's with the case that's being retired, it's not an evidence of guilt, the fact that there's retirement there.
Retirements can arise in different circumstances, but looking generically at when a prosecutor retires and dismisses a case, does that suggest that the defendant is actually innocent? Although there can be variation in the circumstances, the answer to that is no. It doesn't make sense that when a prosecutor decides this person is innocent, that they would just leave the case sitting out there. It may happen occasionally, dockets get overcrowded, but if you're thinking about in the mine run of cases, do we think that all of the people with their cases that are retired and then dismissed are really truly innocent, such that they should be able to then turn around and subject someone else to a lengthy civil suit? I don't think that is what a retirement normally means.
So your position is, in essence, then, that if there were ever to be a malicious prosecution claim, successful malicious prosecution claim, after a retirement, the dismissal papers would have to say something to the effect of, we no longer, we don't have proof this person's innocent, or something to that effect, before you could ever pursue a malicious prosecution claim when there's a retirement.
That's correct, and that is consistent with Parrish and Himelfarb. So Parrish says it has to be a merits determination, and that does make it harder to bring a malicious prosecution suit, but that's the...
Well, counsel, what qualifies? Would it have to be a jury trial every time? What qualifies as a merits determination in favor of the plaintiff here?
Well, I think the example that Justice Bivens just gave, if the dismissal papers say that the prosecutor concluded that no crime had been committed or that the case was not suitable.
That's probably not going to happen in the real world. No prosecutor's going to do that.
Well, there are jurisdictions in this state where prosecutors, as I understand it, make a regular practice of announcing their reasons. But it's also the case that if this court announces a clear rule, if a defendant really wants to bring a malicious prosecution case, they can ask, and in the retirement context, they have some leverage. They can ask for the prosecutor to make clear the reasons for dismissal. So in the retirement and dismissal context, a defendant could say, I'm not willing to waive my speedy trial rights unless the motion for retirement makes some indication of why this is being done. I think it's helpful here to think about the facts of the Himelfarb case, the underlying case. So, as Your Honor likely knows, that was a medical malpractice case. The plaintiff had sued several doctors, and when she discovered that one particular doctor was not responsible for her injury, she dismissed the case against that doctor. And the court nonetheless held that because there was nothing in the objective record evidence showing that it was a merits determination, the doctor couldn't go forward with his malicious prosecution suit.
But there's also a specific rule in the civil context, Rule 41, that says when it's a voluntary non-suit, it's not on the merits. We don't have that in the criminal context.
There's not a rule that says that, but I don't think anyone here is disputing that a retirement and dismissal isn't generically, by its nature, it's not a merits adjudication. The judge doesn't consider the evidence, the jury doesn't consider the evidence, and maybe the prosecutor made a determination about the defendant's guilt or innocence, but maybe the prosecutor just decided there are too many other cases going on, I don't have the bandwidth to handle this, there's a witness who's scared, or something to that effect. When a case, I think Tactile says in their brief, a retirement and dismissal doesn't indicate any kind of particular finding on the merits. I think that's true. And because it doesn't indicate any kind of finding on the merits, under Parrish, that doesn't get you to a malicious prosecution claim. And under the rule of Himelfarb that restricts the evidence you can look at, even when it seems, as in Himelfarb, that it may well have been a dismissal because of innocence, that's just not enough to go forward.
So, counsel, is it your position then that it would never be appropriate to look outside the face of the record in the case that was allegedly initiated maliciously? So, for example, if there was some other, objectively ascertainable evidence about the reasons why the prosecutor ended up dismissing the case, could that be permissibly considered in determining whether it was a favorable termination?
Well, the Himelfarb court just said to look at the record. And so because Himelfarb governs this case, our position is, yes, that as the Himelfarb court said, you should restrict yourself to the court record, because otherwise it's getting into full discovery. And what the Himelfarb rule does is it avoids the costs of getting into full discovery, and those costs are significant. And for individual witnesses who go to a prosecutor, the thought of being dragged through an entire civil discovery with depositions and trying to track down the prosecutor, that is an important deterrent effect. And that's what motivated the Himelfarb court. I mean, that's what it said, that it understood that the malicious prosecution tort could have a significant chilling effect. And it is even more important to be conscious of that in the criminal context, where you don't want to deter people, deter witnesses from going to prosecutors and saying what they know and being willing to cooperate with the rest of the prosecution.
So, counsel, do you essentially agree with the second restatement on malicious, on unjustifiable litigation, wrongful prosecution, malicious prosecution? Says that criminal proceedings are terminated in favor of the accused, and it lists a discharge by a magistrate at a preliminary hearing, the refusal of a grand jury to indict, the formal abandonment of the proceedings by a public prosecutor, the quashing of an indictment, an acquittal, and then a final order in favor of the accused by a trial court. Is that essentially what you are advocating? Would you add the proviso that Justice Campbell has indicated, that if there's, barring discovery, if there's objective information out there, the plaintiff can use that? That was a big question.
No,
You want me
well, I
read
just
the
want to make
list
sure I
again?
get all the pieces out in my answer. So the restatement goes on to say that if there's something about the dismissal that indicates that it does not in some way reflect innocence, then it's not a favorable termination. So I agree with the restatement with both pieces of that, with the proviso that Justice Campbell has articulated, which is that as the
Which is
Himelfarb
not
court.
present here, correct? There's no outside objective evidence?
Right, the plaintiff hasn't pled that any such thing exists or suggested that he could plead that. As I said earlier, the core effect of the Himelfarb rule is to limit civil discovery and to say that if you want to subject someone to a malicious prosecution suit, you have to have gotten some sort of disposition that in some way indicates that you're innocent. And that rule is in fact even more important and more valuable when the underlying case is criminal, because discovery about the disposition of the case is a lot harder when the underlying case is criminal. And there are a couple of reasons for that. One is that a defendant whose case is retired and dismissed has the right to have their file expunged. And anyone who is a sufficiently zealous litigator to bring a malicious prosecution suit is very likely going to take advantage of that. So there are probably not going to be documents that the defendant in the malicious prosecution suit will have access to. So at that point, you're relying on the prosecutor to testify. And there's a sort of asymmetry when the underlying case is criminal that doesn't exist when the underlying case is civil. So when the underlying case is civil, the parties just flip. The plaintiff becomes a defendant and vice versa. So the woman who brought the Himelfarb case, she became the defendant in the malicious prosecution suit. She knew why she had dismissed the case. She knew everything that had happened in the case. But the defendants here were not party to the criminal suit. They don't have firsthand knowledge of why the prosecutor dismissed the case. So they have to rely on finding a prosecutor who remembers these events, which took place in 2015, and then is willing to testify or can be subpoenaed. So that is a pretty difficult discovery problem, and it is one that makes the Himelfarb rule especially suited to underlying criminal cases. That, in addition to the fact that I think I raised earlier, that it's especially important not to chill this sort of activity when the underlying case is criminal.
To clarify, you're not suggesting that a different rule should apply in the criminal context, but just that the same rule that you point to Himelfarb as creating should also apply, at least equally apply.
Yes, that's absolutely true. And that's actually the core of what we are saying here is just the Himelfarb rule applies here. It's not an extension of the Himelfarb rule to resolve this case in defendant's favor. It is just an application of the Himelfarb rule. And the plaintiff here is the one who is saying that for the first time, this court should create a split in the favorable termination element between civil and criminal cases. But courts in this state have always evaluated the favorable termination element in the same way. And I think a way that you can really see that is that everyone agrees that Parrish applies here. Even though the underlying case in Parrish was civil, everyone says you have to make sure that it's a reflection or an indication of innocence. So if Parrish applies, Himelfarb, which is really just a refinement of the Parrish rule, should apply equally in this case. And under Himelfarb, plaintiff just doesn't have a case.
Well, aren't civil cases and criminal cases very different in this context, in this regard? In a civil case, the original defendant just gets served with a summons, is sued. In a criminal case, like in this case, it was a sealed indictment, direct indictment. So in those cases, the defendant is arrested, taken to jail. If it's on a Friday afternoon, it may be Monday morning before that person can make a bond. So he or she has spent, 48 hours or more in jail. And I guess that might go to damages, but to me it also makes a difference in how we look at the civil case versus the criminal case, the underlying case.
In the sense that the criminal defendant is more in need of some sort of remedy because the harms are more severe? I think
Yes.
that may be true in the run of cases, but it is balanced by the fact that the problems of deterring people from going to prosecutors are more severe when you're talking about criminal cases. People should feel free to go to the courts with civil cases, but it is a little bit less of an overall societal concern than it is if people are scared to go to prosecutors. And it's really individual witnesses where I think if someone is scared that if they talk to a prosecutor, they may be wrapped up in years of civil litigation by someone who, like Mynatt, consented to a retirement, left the question of his guilt open. So the Tennessee Court of Appeals said, and I'll read here, talking in general about the question about compromising, the accused having consented to a termination which leaves open the question of his guilt and possible conviction cannot take advantage of it, meaning can't take advantage of that termination to turn around and bring a malicious prosecution suit. If someone agrees that the case against them can be retired and then is dismissed on the next court day a year later, they have essentially bought peace, and they can't then turn around and subject defendants to years of litigation and discovery and depositions and the costs of all of that. And that's what's happened here.
Are you contending that because Mr. Mynatt agreed to waive his speedy trial rights, that there was some kind of settlement here?
So I think there are two completely independent grounds on which the court can resolve this case. This court can just say, under the Himelfarb rule, he hasn't pleaded what he needs to, that's the end of the case. Separate from that, yes, I think the court could say he agreed to waive his speedy trial rights in order to get the case retired, followed by a dismissal. And that is the sort of compromise that leaves the question of his guilt open. And having bought peace in that way, he then can't turn around and bring a malicious prosecution suit. And I think that would be consistent with a lot of Tennessee law saying that if you do something to get a quick dismissal that leaves the question of your guilt open, then you don't get to take advantage of it and subject someone else to litigation.
Which party would have the burden to prove that there was a settlement in this case?
It's the plaintiff's burden to show that there is a favorable termination.
But does that carry over to whether or not there was a settlement?
I think the plaintiff, in having to show that there's a favorable termination, has to show that there's no settlement, that there's no kind of compromise. It ultimately is the plaintiff's burden. If the court doesn't have any other questions right now, I'll reserve the rest of my time for rebuttal.
Thank you. Sorry, I can't see that table over there. I guess, come on up.
Good morning, and may it please the court. My name is Lindsay Smith. I'm appearing on behalf of the appellee, Mr. Kenneth Mynatt. I appreciate the opportunity to appear before this honorable court today. I want to begin by pointing out what Justice Page has already mentioned here this morning, and that is that this case is before the court on a Rule 12026 motion to dismiss. We are here to evaluate a Rule 12026 motion to dismiss based on a complaint that alleges, on November 28th, 2016, all charges against Mr. Mynatt were formally dismissed. A complaint that also alleges that the charges against Mr. Mynatt were dismissed because the prosecutor determined that Mr. Mynatt was innocent. A complaint that also alleges that Mr. Mynatt repeatedly refused all deals and all attempts at settlement with the state. And a complaint that ultimately alleges that the criminal case against Mr. Mynatt was terminated in his favor on the merits. So the task before this court today is to determine if the trial court was correct that taking all of these allegations as true and drawing all reasonable inferences in Mr. Mynatt's favor, is there truly no set of facts that would allow Mr. Mynatt to show that the criminal case against him terminated on the merits in his favor? The Court of Appeals reached the correct conclusion in evaluating this claim. Specifically, that the trial court erred, that it is not possible that there's no set of facts that Mr. Mynatt could prove to show that his criminal case terminated in his favor on the merits. And the reason why is simple. A retirement in this state is a non-final, temporary case posture in criminal law. Appellants have used language like generically or retirement does this under the law, and so on and so forth. However, generically is not the case posture that we're at right now. The case posture that we're at is a Rule 1202-6 motion to dismiss, meaning that this court has to take what Mr. Mynatt said is true, which is that the retirement in his specific case did not result from settlement, did not result.
Counsel, let's assume that I agree with you that the retirement in this case was not the result of a settlement. We still have to deal with the fact that this case was ultimately dismissed, and your client has to be able to point to something. And let's also assume that you have to be able to point to something objective, some sort of objective evidence to show that the dismissal in these circumstances, in this case, was a favorable termination. So what allegations are in the complaint that would satisfy that requirement?
Specifically, Mr. Mynatt has alleged that the charges against him were dismissed because he was innocent. He has alleged that this was a political conspiracy and that charges were brought against him fraudulently, that the defendants knowingly lied to law enforcement, and the dismissal confirms that the prosecution agreed with Mr. Mynatt's position in the underlying criminal case. Otherwise, they wouldn't have dismissed the case.
Does he point to anything on the face of the dismissal document, or I guess any other documentary evidence that would show that that was in fact why the prosecutor dismissed the case?
No, Your Honor. However, our position is that according to Sewell versus Parcable, which is the prevailing authority for criminal proceedings-based malicious prosecution claims, that the court has the ability to go beyond the face of that dismissal order.
But isn't that part of Sewell inconsistent with Himelfarb?
That's correct. However,
Himmelfarb's the last word on it, right?
well, Himelfarb, it's our position that Himelfarb is only directed towards civil voluntary non-suits, that it did not address.
The principle in Himelfarb is contrary to the part of Sewell that you quoted, right?
As it pertains to civil voluntary non-suits.
Yeah.
However, it's our position that that case didn't intend to touch criminal voluntary dismissals in the same way. And I had the opportunity to listen to the oral argument for the Himelfarb case prior to coming before this court today, and there's no mention of criminal cases in that argument. The briefing doesn't mention criminal cases. The ultimate opinion doesn't mention criminal cases. The Himelfarb court doesn't seem like it was intending for that rule to extend to criminal cases. Certainly, this court has the opportunity to extend it here today. However, our position would be that that is not proper for a couple of reasons. Civil defendants and criminal defendants are in a materially different position when it comes to the consequences of having that particular action brought against them. A civil defendant, and this is something that was mentioned during the Himelfarb oral argument, a civil defendant has other avenues of redress if somebody brings fraudulent litigation against them. Specifically, even after a voluntary non-suit, they have the opportunity to seek sanctions and have their fees awarded from the other side. A criminal defendant does not have that same opportunity. Further, a criminal defendant is afforded a constitutional presumption of innocence, something that a civil defendant does not have. Rule 41 says that after a civil case is dispensed with the voluntary non-suit, that the parties are back in the same position they were before the suit. There's not this same idea of a constitutional presumption.
Aren't there other policy considerations in criminal matters that what you are proposing, you would agree, is a minority view in the country, right? I mean, what you're proposing is in line with the Restatement Third's version of this, which they say in the comments is a minority view in the country, and is against the direction of the evolution of malicious prosecution, not only in Tennessee, but in other states as well. You would acknowledge that, right?
I would acknowledge that, Your Honor. I would point out that as this case has been pending, and obviously this court has the opportunity to resolve this issue under Tennessee law. However, as this case has been pending, the Supreme Court of the United States picked up a similar case
But it
with a
was
similar
also
issue.
interpreting what the situation was in the 1800s for the purpose of interpreting Section 1983. So that's really does not indicate what the status is across the country in state common law on malicious prosecution, right?
Perhaps, Your Honor. However,
I mean, it was looking at malicious prosecution in the 1800s, am I right?
That's correct, Your Honor. I would point out that the practical effect of that is the practical effect of the rule that the appellants are suggesting is something that the court did address.
Let me ask you a couple of other questions, though.
Sure.
In the criminal context, there are also other significant considerations. For example, the defendant in the malicious prosecution case does not have control of the proceedings. They may give information to the prosecutor, but the prosecutor may dismiss the matter for reasons unrelated to the merits. The office may have scarce resources. They may be, they may be not prosecuting cases because of COVID. There are any number of reasons not related to merits and not in control of the malicious prosecution defendant. And also, doesn't the evolution of the common law on malicious prosecution in the criminal context reflect the fact that we are now seeing malicious prosecution cases used as a cudgel in a number of contexts? For example, it's recognized that that is a ready weapon for in domestic violence cases where a woman has sought an order of protection, and if the order of protection evaporates for some reason, then the estranged boyfriend, husband immediately implements a malicious prosecution case with exhaustive. And in the discipline of lawyers, we're seeing it in that arena as well. Doesn't that, all of that augur in favor of us not adopting a minority view on this issue?
Tennessee has unique protections that other states may not have when it comes to good faith reporting to law enforcement. So for instance, the domestic violence example that Your Honor just gave, in that situation, the defendant for the malicious prosecution claim would simply have to assert their immunity under the public interest privilege or under the common interest privilege. And the legislature has made that very easy to do with the Tennessee Public Participation Act.
So we want for a woman in a shelter with no money or resources to be in the position of, who's representing herself always, to be in the position of researching Tennessee law to see if she has a defense like that? Is that what you're saying, that we should create that situation?
Perhaps in that situation, it would not necessarily be ideal for that particular defendant. However, and we've cited in our brief, there is a case where this exact situation has played out with a domestic violence victim. She was able to immediately assert her rights under the Tennessee Public Participation Act, have the malicious prosecution claim dismissed, and have her fees awarded.
But the larger issue is, why really would we adopt a minority position in the nation on this issue? And I'll let you speak to that, but I want, I do want you to address the significant policy considerations, including the fact that the defendant in the malicious prosecution case does not have control over whether the proceedings are implemented. For example, in domestic violence cases, the prosecutors will sometimes go ahead and file charges against a defendant, even if the woman changes her mind, says, I recant. Address the unique criminal considerations there.
apologize. The question was kind of long, and so I think
Worst question ever. Why don't you just address why we should adopt a minority view across the country?
and I want to make sure
instead of questioning, so I apologize.
I want to make sure that I'm understanding the question that you're asking. So you're asking why should we adopt a minority rule to look beyond the dismissal, the four corners of the dismissal, and look at the circumstances of the case. Yes. And I hate to sound like a broken record, but I would just go back to the unique position that a criminal defendant is in. I understand there may be some exceptions for somebody rightfully accused of domestic violence. However, on the whole, criminal defendants have virtually no control over the proceedings in front of them the way that a civil defendant does. So a civil defendant can, for instance, file for summary judgment and avoid a voluntary non-suit and get themselves into a position where there is something more clear, something more concrete that the court can look to say this is a favorable termination on the merits. A criminal defendant does not have that same opportunity. And I know the appellants addressed this kind of from the opposite perspective. However, a criminal defendant is in need of redress in a way that is very different from a civil defendant. A criminal defendant has, and I'll allow the Tennessee Alliance for Criminal Defense Lawyers to speak more to this because they're the experts in that area, but a criminal defendant has a whole host of collateral consequences that come along with being charged with a crime. Even if they are able to quickly dispense of the case, as I believe Justice Page pointed out, they may have spent a weekend in jail. They are
So
forever.
are you advocating for a malicious prosecution plaintiff to be able to take discovery from prosecutors? For example, if prosecution was dismissed because a witness was intimidated and disappeared or refused to testify, you want to ask a prosecutor about that?
That would be one way that it could be done.
So you're saying yes?
Yes, Your Honor. That would be.
Go ahead.
No, I think Justice Kirby's alluding to, I just have a concern here about the policy that we might create, because a district attorney general in this state is in a very powerful position. Some would argue more powerful than a judge. And I'm concerned about creating a rule where a year or two after dismissing a case, as Justice Kirby alluded, the prosecutor ends up having to come testify in a civil case about why that was dismissed. And there are many reasons why a case doesn't go forward. The most common one I saw in the criminal arena is witnesses are intimidated, witnesses are afraid to come forward. And many times a prosecutor would not want to divulge that information because it could be dangerous. So how do you respond to that?
I would respond to that and by pointing back to the procedural posture of this case. I think we're getting a little bit ahead of ourselves when it comes to how any defendant should be treated. In this case, we're at the motion to dismiss phase. We have Mr. Mynatt coming forward with sufficient allegations that his case was terminated favorably on the merits. Isn't
a plaintiff always going to be able to make that allegation? I mean, I suppose it would have to be on, there would have to be a basis to make that allegation, some good faith basis to make that allegation. But I mean, is it your position that anytime a malicious prosecution plaintiff says, makes an allegation that the case was dismissed because the prosecutor determined that the criminal defendant was innocent, that is sufficient to go forward and to open the door to discovery along the lines we've been discussing?
That is our position because in reality, a malicious prosecution claim is incredibly difficult to bring regardless of the favorable termination element. There are still other elements that you have to prove that are incredibly difficult to prove even at the motion to dismiss phase. And this is something that the Thompson versus Clark, the Supreme Court case, pointed out. We're not just completely removing all hurdles and opening the floodgates to malicious prosecution claims. Instead, we are just making one element, we're creating a situation where one element doesn't completely preclude all criminal defendants besides those who have been acquitted or who have been convicted, and then it is later determined that they were wrongfully accused and they're exonerated. Because the rule that the appellant suggests, that would be the situation that we would end up in. It would be very, very difficult for any criminal defendant besides those who are acquitted or the wrongfully convicted situation that I just mentioned to be able to maintain a malicious prosecution claim. It would be nearly impossible.
Counsel, let me hone in for a moment on what you're suggesting the appropriate standard truly is. Because at one point, it looks like in the Court of Appeals brief, Mr. Mynatt advocated for a standard of in a manner not inconsistent with innocence. And in the brief to this court, it was stated as allows an inference that the accused was innocent. But then you've also taken the position that you agree with Tactile that the relevant inquiry is inconsistent with innocence and indicates guilt. Are those the same? What standard are you advocating for us to adopt?
We are advocating for the court to adopt an inference of innocence standard. And so if you look at the various Court of Appeals opinions that have interpreted this so far, there is a lot of dissonance between what the Court of Appeals has said. So on one hand, there's the 2020 case Collins versus Carter, and in that case, the court suggested this inference of innocence standards. However, in Mr. Mynatt's case, the Court of Appeals suggested the indicates innocence standard. What we're advocating for is simply that a criminal defendant, a former criminal defendant, is not excluded from the courthouse for a malicious prosecution claim if they can show that their criminal proceeding was terminated in a manner that is not, that allows an inference of innocence. So something such as a dismissal. And I know I keep bringing up the federal standard, and I'll do it one more time here, although I can't promise it'll be the last time. The standard that the Supreme Court of the United States just adopted was one where anything that's not a conviction is able to go forward. And so the standard that we're asking for is significantly more rigid than that proposition. I would just move on. I just want to emphasize a few things, unless the court has any further questions for me. I can't emphasize enough the procedural phase that this case is in right now. Mr. Mynatt has alleged what he needs to allege in order to overcome a motion to dismiss. We're not at the summary judgment stage as they were in the Parrish case. We are not in a procedural posture where he needs to do more than what he has done. An interim retirement is a non-final, temporary case posture. It should have no bearing on what ultimately happened in this case, which was that the case was dismissed. And finally, this is something that appellants argue in their briefing but didn't argue here today, but I do want to briefly touch on it. Diversion is not the same thing as a retirement followed by a dismissal. Judicial diversion, pretrial diversion are both defined by statute. And this is important because this is a large part of the trial court's ruling, is that what happened in Mr. Mynatt's case is akin to some sort of diversion. And that's just not what we have here. Diversion requires agreement of the defendant, whether pretrial or judicial. Judicial diversion requires an admission of guilt. Both forms of diversion require the defendant to be supervised in some manner, whether it be via a memorandum of understanding with the prosecution or on supervised probation with judicial diversion. None of those aspects are seen in this case, and therefore it is absolutely incorrect to equate this case with diversion. And so that point specifically, this court should uphold the Court of Appeals opinion. Further, Himelfarb does not and should not apply to criminal cases for the reasons that I've already stated. Criminal and civil defendants are in a fundamentally different position. Civil defendants have opportunities for redress beyond a malicious prosecution claim, whereas criminal defendants do not. criminal defendants have a presumption of innocence, whereas civil defendants do not. And so this court should take this opportunity to clarify the standard. What we're asking for is that anything that allows an inference of innocence would allow a malicious prosecution claim to at least get in the door. However, even if the court were to clarify that the indicates innocence standard is the appropriate standard, Mr. Mynatt still clears that hurdle at this stage in the proceedings. And I would cede the rest of my time to Tactile unless this court has any further questions for me. Thank you so much. I appreciate it.
Morning. Ben Rabin of the Nashville Bar, on behalf of the Tennessee Association of Criminal Defense Lawyers, is the Amicus curiae in this case. I think all of my criminal defense attorney colleagues across the state would be a little bit baffled that we're debating whether or not a dismissal could be a favorable termination for a criminal defendant. A dismissal by a prosecutor is really the best result we could ever have in a case, even better than an acquittal at trial, because it means we've spared our clients from the expense, the time, and the risk of going to trial. So a dismissal is the best result that we could really ever have. And so I'm troubled by the idea that I could get the prosecutor to dismiss my client's case, but tell my client that we need to reject that and somehow try to object to a dismissal and insist on trial to preserve a potential malicious prosecution claim. And I think that...
But counsel, you will concede there are many reasons for dismissal other than innocence.
Absolutely.
Reluctant witnesses,
there
intimidation, many others.
There are. And I think that's the problem, is that because that's true, and if we say because it may have been for some other reason, then we're going to say, well, no dismissal is ever enough. And then I think if you apply that same reasoning, you can say no acquittal by a jury is ever enough, because all the jury says is not guilty. 2 words. That just means they have some reasonable doubt about some element of the case. And there could even be some technical issue that the jury finds. So if we apply the same logic, and the only way that is to have some affirmative showing by a prosecutor or a judge, then almost nothing would qualify. And I think that's the concern I have with what the appellants are proposing, is that we're basically never going to have a malicious prosecution suit move forward unless by
That's
some...
not the, what you're talking about is not the standard in the majority of states, right? In the majority of states, an acquittal will work. But the majority of states do not sanction discovery of prosecutors and going into the underlying proceedings, right?
I can't speak to I haven't done a survey of the cases, so I can't speak to that. I would say if that is the rule, I would disagree with that. And I would submit that what the Supreme Court found going back to the 1800s is the right rule. And I think, this is a common law tort. It's not codified in the statute. It's emerged from the common law, and there have been developments of that. And I think the concern is, particularly with civil cases, I think that courts have too narrowly construed that because there may be these procedural issues. And I think that as we go too far, I think what we're running into is having the exception swallow the rule, where again, if we're requiring some showing of innocence, then again, by that logic, an acquittal is not enough.
I'm sorry, go ahead. Let me ask you, Mr. Rabin, what I asked Ms. Smith with regard to what standard are you asking us to adopt? And she indicated that her clients were requesting an inference of innocence standard. Do you agree with that standard?
I think so. I think that the best way that I can think to approach it is, has the defendant been ordered to or agreed to do something that is inconsistent with innocence? For example, paying restitution, doing community service. Has there been something that they've done that suggests sort of an admission or recognition of guilt? I had a case earlier this week where a person was charged with vandalism. The person paid cash to the victim on the spot, and the prosecutor said, well, good enough for me, case dismissed. The case was dismissed, and yet clearly by paying the restitution, that was them doing something. It's inconsistent with innocence. And I think for that to play out for one reason or another, that's probably not enough for the person to at least win a malicious prosecution case. Whether it's enough to get in the door past a motion to dismiss may be a different case, but I think it wouldn't go very far. And so I think, as Your Honor kind of indicated, the terminology, is it inconsistent with innocence? Is it consistent with guilt? And it's sort of different sides of the same coin. But I think as a practical matter, to me, the suggestion I would have is, has the defendant done something? Is there something somehow that indicates the defendant has been ordered to or agreed to do something that acknowledges or recognizes guilt?
Mr. Rabin, what about waiving speedy trial rights? Is that inconsistent with innocence?
I don't believe so in this case, because the speedy trial right is to protect the criminal defendant and I put some case law in my briefing on this, that it's to avoid the stress of having the case hanging over you, the destruction of evidence, and those are really to protect the defendant. If you're guaranteed to have a dismissal, then I don't think so. I wanted to address the policy.
Just before we move on from the standard, so do you see any daylight between the inference of innocence standard and the not inconsistent with innocence standard? Or are you sort of treating those as one and the same? I think in your answer to Chief Justice Page, you referred to inconsistency with innocence.
I think it's kind of one and the same. I think maybe it comes down to sort of who has to make that showing, and does the civil plaintiff have to show that there is something there? Or, I think it's just sort of one and the same, quite frankly. And I think it's just sort of semantics. And again, I think you just look at the underlying, what happened, and was there something in the record that shows, some finding? Because again, I think in the absence of any finding of guilt or innocence, I think we should sort of presume innocence. I think there should almost, if there is a dismissal, if the case does not result in a conviction, I think that may be sort of a presumption that it was from innocence, unless there's some indication otherwise, which may happen. But again, otherwise we're in a situation where even an acquittal, we say, well, there's no affirmative showing of innocence there.
So, I'm sorry, go ahead.
Just one more question. Are you aware of any jurisdictions that have adopted different standards depending on whether it's a criminal or civil case?
I have not, but my position would be that the rules are just different. That Himelfarb looks at, Rule 4101, that looks at this language specifically in the rule that says this is not an adjudication on the merits. That rule is not in the criminal, or that language is not in the criminal rule. So we're not making a different rule in the standard. We're just recognizing that the underlying procedural rules in criminal and civil cases are different.
Well, Rule 41 in the civil context doesn't actually say that a dismissal is not an adjudication on the merits. It says that after a third, that is an adjudication on the merits, right?
I believe it says, unless it says otherwise, that a first one is. I believe so. I could be mistaken on that. It could be the case law. But I believe the rule says that it is the first time, at least, unless otherwise provided. And so again, but the criminal rules, they just don't speak to that.
Let's move beyond. If we move beyond that, the Rule 41 context, and we're just talking about, some other disposition in a civil case, would you still suggest that there's a different standard that should apply?
I think maybe. Again, I think that the criminal and civil dispositions are simply so different of how that works and why it happens. You've got a prosecutor making the decision versus the civil defendant, the criminal complaining witness turned civil defendant. I think it's just such an apples and oranges thing that to have the same rule is just too difficult to it. So I don't see any reason not to say that we'll treat these differently, even if you say the rule is the same, to kind of treat them differently just because the underlying basis of how and why those cases are adjudicated is so fundamentally different.
Thank you, Mr. Rabin.
Thank you.
We're ready for rebuttal.
Thank you, Your Honors. I think that most of the issues have been covered here at some length, so I don't have much to say unless the court has further questions.
I think we're good unless Justice Lee has something. I can't see her.
All right, thank you. Then I'll rest on our earlier submission that just... Oh, I'm sorry. Do you have something, Justice Lee?
No, I was going to say, I think every question I had has already been asked, so thank you.
Thank you. Then because Mynatt has not met his pleading burden under Himelfarb, we submit that this case should be dismissed. Thank you.
Thank you all. Appreciate the arguments.